Good morning, good afternoon for those who are joining. Thank you and welcome to our Questel Roundtable. We will start in 2 minutes. Time to get people to join. Thank you for your patience. Good morning, good afternoon. I can see some people joining. Thank you for joining us. We'll start in about a little minute. Welcome, Randy. If you have any questions during the presentation, don't hesitate to click on the little box on top, and you can ask your questions. We'll read them, we'll moderate them, and we'll try to answer on the fly or at the end of the presentation. Again, thank you. Hello, Pikovic. Welcome. Okay, we're going to start. So again, good morning, good afternoon for people joining from Europe and the United States. Thank you for joining us for this Questel Roundtable. I have the pleasure to moderate this session. My name is Gilles Cruenest. I'm based in Questel Inc. in the USA, and I'm based in California. I will introduce the speaker in a minute. I will just do a little introduction of the topic of today, and I hope you will find that presentation insightful and interesting for your business. So despite the current economic outlook, headlines show that large licensing deals are still being negotiated, and potential dispute over France and licensing of SEP is continuing to grow. It is likely to expand further with the emergence of 5G, as you know. And HC declared there's about 80,000 patents that embark this technology. So we know that there will be certainly emergence of potential litigation. In this context, we have organized this roundtable among telecommunication, automotive and transportation, and SEP experts from Europe, Asia, and USA to discuss ways to manage and mitigate cross-border dispute and litigations, and also get some updates about the ETSI standard organization, the EU IP plan, and also news from the US. For this roundtable, I'm pleased to be supported by 3 keynote speakers. First, David Barkan, who is the principal at Fish and Richardson, who is going to introduce himself in a minute. Dr. Nikolaus Thumm, who is based in Berlin and who is kindly joining us from the evening time in Europe. And Sachin Sinha, who is my colleague based in India in the company Concur IP, which belongs to Questel, and who specializes in SEP evaluation and assessment. So I will let David Barkan introduce himself before I will introduce the other speakers, and then we will start going deep into the topic. David, you can present yourself. You're on mute.
Thank you very much, and good morning, and good evening, and good afternoon to everyone. My name is David Barkan. I'm a principal in Fish & Richardson's Silicon Valley office. I've been litigating patent cases for almost 30 years now. And over the last 10 years, I've had a particular focus on SEP and FRAN matters, including really 3 major areas. One is arbitrations. Another is portfolio level valuations, sometimes for negotiation purposes, sometimes in litigation. And then lastly, the limits that FRAND places on patent damages for individual patents. Most of my work over the last decade in this area has been in the telecom area, but I've also had contacts with SEPs in other areas. And with that, I'll pass it on to our next speaker.
Thank you very much, David. We'll have Dr. Nikolaus Thumm to introduce himself. Nikolaus. I think you have to unmute yourself. We can't hear you. Maybe I'll come back to you in a minute. I will let Sachin. Now you're there?
Yeah, I'm there. Sorry, there was a technical problem.
Yeah, no problem. No problem, Nikolaus.
Okay, so my name is Nikolaus Thumm. I'm currently associated with Technical University of Berlin as a research associate, and previously I've been working for the European Commission at Joint Research Center, and there I've actually been in charge of a set of projects in the field of front licensing, patent assertion entities, and the last project was actually I'll come back to that, probably we'll get back to that, the pilot project for standard essential patents, and so focusing a lot of essentiality testing. And before that, I was chief economist with the European Patent Office, and I've been also working in the past with the Swiss IP office as a senior economic counselor.
All right, very interesting. Thank you, gentlemen. And then I will finish with my colleague, Sachin. Sachin, if you could introduce yourself.
Thank you, Gilles. Hello, everyone. My name is Sachin Sinha. I have educational background in electronics and telecommunications, and I have been working in the IP space for the last 15 years. I started my career with a telecom company in India, and then I worked with Thomson Reuters and Ernst & Young before founding Concur IP in 2015. My primary work area has been standard essential patents, helping corporates and law firms with SEP licensing and litigation matters. I have led large teams of telecom engineers and IP professionals in performing studies on standard essential patents that have been relied upon by companies, economists, and courts to determine FRAND rates for SEPs. Some of the cases that I have been recently involved with include TCL versus Ericsson, Unwired Planet versus Huawei, Osus versus Interdigital, and a few international arbitrations as well. Thank you.
Thank you, Sachin. So let's come back to our agenda. So I will start moderating some questions to our audience, and I will start with David. So David, and by the way, if you have any questions during this presentation, don't hesitate to click on the little box on top, write your questions. We'll address them on the fly or at the end of the presentation. So please don't hesitate to drop your note. So David, can you provide your perspective about the jurisdictions aspect of SEP litigations, especially when large multinational companies with worldwide patent portfolios are involved?
Thank you. This is probably the most dynamic area right now related to FRAND and SEP litigation. And I generally divide the world into the time before Unwired Planet and the time after Unwired Planet. So the basic model before Unwired Planet is that in most countries and in most courts took a limited view of their jurisdiction. Their primary goal was to decide the dispute that was before it, which was usually limited in geography to patents just in the country where the court was located, and also often limited to just a handful of patents for which infringement was alleged and proven, and the patents were shown to be not invalid. And so that was the model. If you were a SEP owner, you would have to bring essentially exemplary lawsuits, and you'd be limited to recovering damages or obtaining an injunction on just a subset of your patents that were actually litigated. One consequence of that is that anti-suit injunctions were not very common. They were not needed because each court took a limited view of its jurisdiction. There were exceptions. Typically, anti-suit injunctions would come up in a scenario where you had parallel litigation in multiple countries, and one court came to the view that the immediacy of an injunction in another country would, as a practical matter, eliminate the ability of the court to adjudicate the claims before it. So, for example, in Microsoft Motorola, there was a Huawei Samsung case where the courts felt that because of the imminency of an injunction, that would, as a practical matter, force the parties to settle, and the court in those cases in the US would never get a chance to actually adjudicate the claims. So before Unwired Planet, the cases where a court would actually take a larger role were typically by consent.
We can't hear David. I think he's a bit frozen.
Yeah, can you hear me now?
Yeah, you're back on track, David.
So in those cases where consent was obtained by both parties, sometimes the courts would seek to set a portfolio-wide rate and sometimes even a worldwide rate. Usually it required consent of the parties in some form. There were sometimes cases where the implementer would bring a lawsuit alleging that the offers had not been FRAND and asking a court to evaluate a pre-suit offer, typically for a global portfolio, and whether it was FRAND or not. And that was the landscape before Unwired Planet. Now we're basically in a brave new world. Unwired Planet created a mechanism, at least in the UK, whereby which a lawsuit brought on just a handful of patents could morph into the court setting a rate for not just a portfolio in England, but a portfolio worldwide. And I think that really shook up people's thinking in a number of countries. Prior to that time, I don't think Chinese courts had attempted to set a portfolio-wide or worldwide rate. After the UK Supreme Court decision, you started to see some decisions out of China to that effect. In addition, the US, prior to Unwired Planet, courts generally avoided addressing worldwide patent issues unless the parties consented. But now, of course, we've got the massive dispute between Samsung and Ericsson, where that issue is going to be presented. And right now, what the parties are fighting about are competing anti-suit injunctions. Anti-suit injunctions issued by the court in the US, anti-suit injunctions issued by a court in China, and then a further layer of anti-suit injunctions preventing each party from seeking further anti-suit injunctions. In the US, that is now going up to expedited appeal to the US Federal Circuit. And I don't think a hearing date has been set on that, but we may get some more clarity, I would say, by this summer on that issue. So that's really a very dynamic area. And I think everybody's watching in the US, Samsung Ericsson, to see what the Court of Appeals has to say about this situation.
Thank you, David. And when it comes to lawsuits involving specific patents versus general disputes on the entire patent portfolio, what's your view on that?
Yeah, so this is, again, somewhat related to the changes from Unwired Planet. Typically, the scope of the lawsuit was somewhat more in the control of the implementer. So if the implementer did not consent to the court setting a portfolio-wide rate, generally the patent owner had to bring infringement cases on individual patents. As a practical matter, if you have a large portfolio with hundreds of patents, you can't bring an action on hundreds of patents. You have to pick some manageable number. Usually at most, several dozen would be probably the most that's practical. Mm-hmm. And then if you prove infringement and you establish the patents are not valid, then you get to the damages phase. And at least under US law, the damages in those cases are limited to damages for the individual patents. And so FRAND is very important because FRAND principles are taken into account in setting the damages for individual patents. Sometimes comparable license data is available, and then it's a lot simpler. But oftentimes, you're really wrestling with FRAND principles boiled down to individual patents. It's a challenging issue, I think, because in the real world, in the business world, it's very unusual for
You're frozen, David.
Hold on just one moment. I think the problem may be on my end.
Yeah, you're back on track.
Hold on 1 second. I am just gonna, all right, okay. So the problem is, as a practical matter, when large companies with large portfolios negotiate, it's impractical for them to do so on an a la carte basis. In very few situations would companies look at a portfolio of hundreds of patents and say, I only want a license for patents 7, 15, 27, and 36. What's your price on an individual patent basis? But that is the way the damages law in the US works. And so in a typical case, you are really litigating on a patent by patent basis, applying FRAND principles as you go. Sometimes the defendant will consent to a larger adjudication. And sometimes there are cases where the implementer wants an adjudication of whether the pre-suit offer was FRAND, and then the litigation will include an evaluation at the portfolio level.
We know that there are alternatives to dispute and litigation, and it's arbitration. What's your view on the merits and demerits of going through an arbitration versus a litigation based on your experience?
It's really interesting. There are definitely trade-offs. I think, first of all, arbitration only happens if both parties agree. And that typically happens in one of two ways. You have a licensing dispute, parties reach an impasse, and they will often decide on all the terms they can agree on, leaving the price blank, and then they submit the price to an arbitration procedure. The other manner in which it takes place is sometimes parties have existing license agreements that expire, and the license agreement has a renegotiation provision. They provide a certain period of time for the parties to try to negotiate a renewal, and if they're unable to, then they submit the disputed terms to arbitration. So that's the context in which arbitration happens. The upside of arbitration is that you, at least in the US, you're not trying to figure out if you're dealing with a judge or a jury. In arbitration, of course, the arbitration panel can be retired judges, it can be lawyers, but in general, you're talking about legal professionals rather than a jury. Typically, there's also no appeal, which means you have a level of certainty in an arbitration that you don't have in a litigation. You can spend a year and a half and many millions of dollars getting all the way through a jury trial in a US litigation, but that's really only Act 1. You still then have to keep your win if you win, or overturn it if you lose on the appeal process. There's a lot more uncertainty. And so I think in situations where parties really believe they can reach a final agreement, and the goal is to reach a final agreement, arbitration gives you more certainty. It can be faster if the arbitration agreement is well drafted. It's not necessarily cheaper. I think people often enter arbitration with the idea that it's always cheaper than US court litigation, and that's not really true. The expense of arbitration depends a lot upon how carefully crafted the agreement is and what limits are placed in there. The other thing I would say is that one potential advantage of arbitration is that in a US court action, even with the most dedicated judge, they have limited time. The judges with deep patent expertise in the US often have hundreds of cases on their docket. And even if they want to devote a lot of time to your individual case, it's hard for them to do that. Of course, in an arbitration, you're paying for the undivided attention of the arbitration panel, and they can spend hundreds of hours digging into the record. So those are really the primary issues. I think arbitration is not really going to be available if the implementer is not strongly interested in reaching an agreement. The advantage of litigation is that it does drag things out. Even if there's a loss, there's still an appeal process. And so it's going to be a longer time frame. It's also harder, as I mentioned, in the litigation to get a portfolio-wide price set as opposed to individual patents.
Thank you, David. I don't know if, Nikolaus, you have some comments based on David's explanation just now before we move to other questions.
Yeah, I mean, if I may, I just immediately react to what David just said. I mean, I fully agree that with Unwired Planet, we're moving into a new dimension, and these anti-suit injunctions that we can see now popping up everywhere in the world is probably a consequence of that. So what it shows to me is that there is a need for international solutions to this. It's not, we cannot leave it to national courts solving international matters, because naturally the reaction we can see that other courts in other countries will not agree with what has been decided in another jurisdiction. So and by the way, I believe that certainly what we see with the court cases, that is very important, but that's only the tip of the iceberg. So as you have rightly pointed out, that arbitration is probably and rate fixing is going on elsewhere, and so it's a lot about evaluation of your technology, and most of that is settled outside of court. So I will address that later then if I can make my statements then. That so I think there is more a systemic problem here we have to solve before then, of course, in the end we get to the courts. But the courts, after all, they're always independent. I mean, you cannot regulate them, you cannot tell them what to decide, and that's fine. That's good as such.
Thank you for that. If you have any question, don't hesitate to pop up in the chat box. I will convey the question to our nice speaker. Nikolaus, if we go a bit more in deep dive into the topic, what do you think are the best entities or organizations placed to perform essentiality check? Because it's always a question which is complex to solve and to sort. How do you see that evolving?
Well, I mean, we've done a little, some work on that, as you may have noticed, and that is indeed this pilot study for essentiality assessment of standards essential patents that came out, and where the Commission, in its recent communications, so the IP action plan, is also referring to. There is also a very interesting additional piece there, and that's the landscape study of potentially essential patents disclosed to ETSI. So for those who are really into the subject, I think they might also look into that one, because it really reveals some very interesting insights. So that has been taken up indeed by the European Commission. So in the IP action plan published in November 2020. And there is also a lot of material out there actually on this issue that came from the group of experts on licensing and valuation of standard essential patents that was published in January this year. And the discussion is going on, is continuing. But what the reports reveal so far essentially is simply that it's feasible. You can do it technically and institution-wise. I mean, that's what you can find in the report. So that's very interesting. Now you're asking, okay, so who would be best, positioned actually to address these issues? And that is now going beyond what you will find there in the reports. There you find a couple of scenarios, and then you will have to make a choice. So what I'm saying now, that's more my personal opinion in this respect. Okay, so who's best suited? I mean, I think that is foremost is actually the patent offices. I mean, despite the fact that they actually have little, if no, expertise as for essentiality testing, and of course they never look into infringement issues. However, I mean, the type of work they're doing is quite similar to the type of work that the experts will have to do when you actually do essentiality assessment. And in the pilot, actually, in this experiment that we have there, it's what the people there, because we've been working there with 6 patent offices. So what they did there is to approximate the essentiality test. They did a novelty type of test. So it's essentially hypothetically checking whether if the standard would have been available at the moment of time you file a patent, so would that have been novelty, infringing? So that type of test, of course, this is really a proximity, but I mean it leads us into the right direction, I believe. So having said that, the patent offices, they have a very strong technical expertise here, and what probably matters more is that people trust in them. So because if you want to have essentiality tests being carried out by somebody that is not the people that usually carry them out on the private market, then you would need an entity that people trust in. And that is clear what has been communicated, and what I also get, what people transmit me, that this is actually on the side of patent offices clearly the case. Now, however, this shouldn't be, only left, of course, to the people with patent offices. I mean, definitely, it's the people in the patent pools, the evaluators that have been doing this type of work so far. They definitely have the expertise for doing this, and they should also be, any system should build on that in a way, right? And also, I believe, since I'm speaking as an economist, and I always think the state should only intervene, when it's only necessary, and when we're really talking about transparency, and that if there is a problem on the market, so that markets are not operating fully transparent. So also other participants, potential new participants, should be allowed to let into a system. So what I would think about possibly would be, that you would have to go through an accreditation process in order to become a qualified, kind of assessor within such a system, and there would have to be some clear guidelines how to guarantee the quality of such checks. Now, I've been very much moving beyond what is current practice now, except of course the patent pool. So, but I think this is an interesting discussion. We could probably go on forever. Right?
Yeah. David, do you agree with that approach, that should be the patent offices to do that? I mean, you're a law practitioner, so you may have different views on that, but do you see that happening in the US as well?
I don't think so, only because I think the US Patent Office tends to not have the resources and not approach its mission that way. I think that may be more practical. For example, in European patent offices, you can do retained searches of prior art. They've done that for decades. In the US, you don't have that ability. So the US Patent Office, I think, doesn't really see its mission that way. My own sense on the landscaping side is that I think sometimes many commentators and experts in the field get too attached to one method. And the reality is, this isn't an easy science. There isn't just a formula to put in. And so there are a whole range of factors, each of which has strengths and weaknesses, and you need to evaluate them in that context. And so what I look for is, what are the kinds of data repositories that are available? What kinds of studies are available? And I usually look for multiple data points to see if they converge on a number. So if I use, a number of different methods, each of which have strengths but can be attacked on certain grounds, but they all give me about the same range for the portfolio value, I feel pretty good then about the number that we've reached.
Okay. And Sachin, you have quite an extensive experience in assessing the essentiality on SEPs and in patents. What's your take on that? Do you see a willingness from public institutions to perform that kind of work, or you believe there's still room for private operators such as Questel to do that?
Yes, absolutely. So, we are typically hired by, our client, who is in a licensing dispute, and we perform an industry-wide essentiality study to show what each company owns in terms of essential patents. So, given the type of the portfolio that we have to deal with, as David said, patent offices don't have that kind of resources to perform an industry-wide essentiality study. They can probably do the study on individual patents when they are asserted in the case, but performing an industry-wide essentiality study to determine FRAND rates for large portfolios, I think third parties, outside consultants like us would be needed. That's my limited view here.
Okay, Sachin, thank you. Nikolaus, as we talk about essentiality check, and we know there's a lot of cost involved to do that, it's quite a thorough mission and job to do that. How do you believe cost to perform essentiality checks can be kept at a reasonable level? Any hints on how to do that?
Yeah, well, been floating some ideas, of course, that you know, I'm in my mind. I really have a more an international approach to this, you know, so where there's more entities involved, and if we get to something like where we really have also patent offices involved, then it would not be only the European one. Despite the fact that, I mean, I make this claim, David, I fully agree. I know very much about the US PTO position on this, so that's okay. But we're discussing this right now very openly, so that's why I just put it on the table. So how to make sure that it's not going to become too expensive. I mean, so you have to think whether to which extent you really need all members in a patent family, or whether you will have to make, you know, a choice for one or another major market country where you might have to do your assessment. And then, of course, also it's and you do not want to end up in a situation where, you know, in such an advert you cover, I don't know, the US market already, but you still have to wait for a decision on the European market. And of course, so in such a situation, you would want to see also a kind of a certification system, so that, you know, that you can move ahead and do not have to wait for yet another administration, you know, to take a decision. So I understand that, and that would certainly become part of it. But to reduce the cost from the front end really is okay. It probably would not be necessary for all members of a patent family, but you make your choice, right? I think that's, and I assume that you do that anyhow, even in pools now, you have to make a choice. So what you want to have assessed and what not. So.
Thank you, Nikolaus. We have a question from Alex, probably to David. What is your opinion on using injunctions in SEP cases?
Yeah, it's interesting because I think the law on this varies depending upon which standard setting organization you're talking about. There are some that just prohibit seeking injunctions. There are others that take no position, and the law has evolved somewhat differently in different jurisdictions. So, for example, in Europe, people look to the Huawei ZTE case as guidance, and the Huawei ZTE case kind of sets out a very elaborate dance between the patent owner and the potential licensee. And if the patent owner doesn't fulfill their obligations, injunction may not be available. If the potential licensee doesn't fulfill their obligations, then injunction may be available. In the US, it's a bit more unclear. There are parties who take the position that injunctions are always inappropriate for SEPs. Personally, I think the only case that has squarely addressed it from the Federal Circuit said actually the opposite. It said that, at least in theory, there's no per se bar to injunctions in an SEP case. And it implied that the common scenario would be an unwilling licensee. Now, one of the problems in the US is we don't know what an unwilling licensee is defined as. You know, what kind of conduct by the implementer would make someone unwilling? Certainly, you can picture extremes of behavior. You can picture a potential licensee who simply politely attends meetings with the patent owner, but clearly drags it out and has no intent to ever sign a license agreement. But beyond those sort of clear situations, we don't really have any guidance. And so the injunction situation in the US is quite mixed. Now, you know, my own view is that US courts have always had a notion that sometimes you can award a going forward royalty in lieu of an injunction. And that in many of these SEP cases, because of the FRAND obligation, that may be the right result anyway. Is that even if injunction is requested or in lieu of an injunction request, you know, should the US courts, once they've done the hard work of figuring out the FRAND rate for the past, set the FRAND rate for the future, and basically condition the implementer's use of the technology on paying the going forward royalty rate. You know, that doctrine exists in non-FRAND cases, and it's been around for quite a long time.
Thank you, David. I will ask now Sachin to explain a little bit what typically a service provider such as Questel do with regards to SEP. Maybe you can share a bit your experience, and we'll go in some technical question afterwards. I hope, Alex, we answered your question, by the way. Thank you for asking your question. Sorry, Sachin, please go ahead.
Yeah, just adding to the points Dr. Nicholas and David mentioned, on the essentiality checks. Based on my experience evaluating large patent portfolios, I think we service providers can play a crucial role in bringing more transparency into the system. We are seeing an exponential rise in the information on SEPs, and it is almost impossible for in-house teams of companies to understand the evolving IP landscape. So, we have tens of thousands of essential patents owned by hundreds of different companies. There are hundreds of different standard specifications from a number of different standard setting organizations. And we have a number of licensing disputes going on at any time with worldwide implications. Now, recently, we have another scenario where there is a cross-industry implication of SEPs. For example, cellular SEPs now have significant applications for the automotive industry as well. So, with all this information flowing, it's very difficult to make important business decisions, taking into account all this. So, service providers like us can help organize the SEP information and present that to companies in a form that they can utilize in their decision-making process. So, just taking the example of EPSI, which is kind of most popular SSO these days. So, companies have made thousands of IP declarations to EPSI, and this information is available on the EPSI database. However, the information is not well organized, and it is very difficult to make sense of that data until it is processed to clean various fields of information such as publication numbers, family groupings, patent owners, etc. So, companies like us can organize that information, and once that is done, we can see the number of patents and families declared by various companies under different technology generations like 2G, 3G, 4G, 5G. So this is a very useful information for the decision-making process, but not easily available without going through the time-consuming data cleaning process. And this is only the first level information on SEP that we're talking about. At the second level, what is useful for companies to know is the coverage of SEPs. That is what the patents actually cover. For example, the claim of a SEP may be directed towards a handset or a base station. Now, a handset manufacturer or a vehicle maker may not have any interest in SEPs that cover only base stations. So this information is very critical for companies depending on the products they manufacture. However, this information is not provided with the declaration, and it requires review of independent claims of the patent to determine their coverage. So obviously, this takes a lot of time depending on the number of patents we are dealing with. But again, this is very crucial information for the decision-making process. Now, at the third level, it is even more technical and time-consuming, and Dr. Nicholas also covered that in terms of how we can limit the cost of essentiality checks. So we all know that a large percentage of declared patents are actually not essential, and that is due to several factors, such as the claims go through amendments during prosecution while they may have been declared as soon as they were filed. Then the standard itself evolve over time. So something, a patent that was essential to an earlier version may not be essential later on. And generally, patent owners prefer to declare their patents when they are not sure whether it is essential or it may be essential in the future. So all of this results in some sort of over-declaration of the patent. So, and also based on my experience, the percentage of truly essential patents vary largely among different patent owners. So I have seen percentage as low as 10% and as high as 60%. So just relying on the declared patents could be unfair to patent owners who have a higher essentiality ratio. So, I think an essentiality check is a must on any portfolio. However, as we know, this is a very time-consuming task, and it's a very technically intensive process. You need to review independent claims of the patents and also read the detailed description to understand the scope of the claim. We also need to review several standard specifications and determine whether the claim aspect is required by the standard or not. So we need people with educational background in telecommunications to understand the technical aspects disclosed in the standard. And we also need IP proficiency to be able to interpret the claim language. So we at Concur IP and Questel, we have done this process several times on thousands of patents in the past decade. In some cases, we have taken a random sample of all declared patents, evaluated their essentiality, and then extrapolated the numbers to estimate the total number of essential patents for the industry. In few other cases, we have simply evaluated all the declared patents. That means, over 10,000 patent families. And that takes a lot of time. I have deployed in some cases 10 to 12 people over several months just to perform this essentiality evaluation. But the end result is that it's a very useful information, and it becomes the basis for royalty rate calculations. So our studies have been used by economists to calculate royalty rates, and has also been relied upon in various court proceedings.
Thank you, Sachin. Maybe I will give back the mic to David just maybe for last question. You have people coming to you, an OEM or a tier one in automotive or transportation or telco company coming to see you and telling you, I need to check essentiality because I have a case. Where do you start? I mean, it's quite a complex topic, complex matter. How do you advise your clients when they come with a case? Is there a general checkup checklist to be done, to be processed before acknowledging that there's a case to be filed?
Yeah, so we're really talking about two different kinds of analyses. So what Sachin is talking about is how do I get a sense at the portfolio level of what percentage of the patents are likely to be essential? You're sort of dealing with the law of big numbers. You really can't spend dozens of hours on any one patent, and the numbers are big enough where you can draw sort of broad conclusions. In the context I think you're talking about is more the pre-suit due diligence you would do before bringing an infringement action.
Yeah.
And the essentiality aspect is pretty critical because in many cases, detection of infringement is quite difficult. So if the patent relates to a particular communications algorithm or power control or other things, it would be very difficult from either publicly available information or reverse engineering to determine actual infringement. And so instead, you look at essentiality as a proxy for likelihood of infringement. You know that a particular commercial product claims compliance with a standard. And so then you really need to look at, is the patent necessarily infringed if someone is compliant with the standard? And what we do in those areas is we work with both our internal experts. Many of my colleagues have masters and PhDs in electrical engineering. Many of them worked in industry before they became lawyers. So we'll find someone on our team who's got the right background. And then we often retain outside consultants as well, technical experts who really know the particular standard at issue. And then you do the analysis, which can be quite time consuming on a patent by patent basis. In fact, one of the really challenging aspects is if a client says, well, I have about 500 patents in this area, where do you start? Once you get it down to a universe of 20 or 30, you can do the deep analysis on those 20 or 30, but getting from the 500 to the 20 to 30 is quite difficult.
Yeah, can imagine. Nikolaus, any feedback on that, on your experience, exposure to
Sure.
cases?
Absolutely. So thanks a lot for these interesting insights, also Sachin, and I fully agree with your assessment. And just to make that clear, I hope that was clear in my initial statement that the expertise as it stands now is with the professional service providers in this area, right? And that's amongst Questel and others probably. But still, I'm trying to push a little bit for a change here. So if we discuss the ETSI database, and you've nicely pointed out all the difficulties that you're coming across, for instance, when you want to reveal insights from these databases, and indeed you need specialist experts to get to that, because for the simple fact that the ETSI database has never been thought at initially to become the source, for any statistical analysis. So to start, I mean, we all know it's there because we're very glad that it is there, because other SDOs don't even have such a database. So I think to start with, but the intent, of course, is, to that companies come up with their FRAND declaration. So they submit, these patents to a FRAND declaration, and there's many people out there that would argue, I'm not one of those, that the more patents they are in the database declared under the FRAND regime, the better, because then you have, of course, you get into different conditions when you get into licensing agreements. Okay, but so. Again, I'm not one of those, because I think there is also there is the initial intent, of course, by the ETSI database that you would only submit, that you should submit, when I think it says somewhere when you really think that it is about an essential IP, but of course the legal obligation makes you to submit your patent at a very early stage, as an SEP. So. And there's a lot of work also in there, as you have rightly pointed out, simply looking into the different patent families and the definitions that are out there, very complex issue. In that respect, again, I would recommend people to look into that landscaping exercise, that report. That could be very helpful in that respect. But then the interesting thing, of course, is, when you also mentioned them, Sachin, as, when we're talking about truly essential patents. Okay, so indeed, I mean, it may be 10% only. It may be, I think we've put a number of 50 to 75 that are not essential. So somewhere in between there, but that comes with the very nature of the database. So my point is that I would not change probably the database as it is, because it fully serves its purpose, right? But if we think about a change to the system, we would probably think about yet another database where you have to actually to reconfirm your declaration at a later stage, because at the stage you have to do this now, it's not about, patents have not been fixed and the standards have not been fixed. So at a moment in time when patents will be granted and the standard will have been fixed, then a declaration about essential or not essential might look very different. Maybe not from a negotiation point of view, but of course, if you combine to such a declaration the immediate obligation, that you will have to go into examination, and that will come with a cost, of course, then, I mean, these declarations might look very different, right? So that's the hypothesis I wanted to bring up here. So.
Thank you, Nikolaus. We open to questions because the time has been running, so we want to get into the conclusion. So please don't hesitate to put a little chat if you have any question to the audience, and then we'll move to the wrap up of the roundtable. So while you might ask some questions, just to conclude and just mention about Questel, just for you to understand who we are, for those who don't know Questel. So we are a global player in the IP field. We're one of the largest IP, SaaS, and services supplier present in many different countries. Just in the US, we have about 200 people supporting our clients. And we deliver different type of services, and part of the SEP is an activity, is a practice which is well managed by our team, our colleagues. And we have global clients that we support in their IP activities, whether it's the early stage of innovation down to the commercialization of their IP assets. So I wanted to thank my great keynote speaker. If you want to say a little word in order, David, and then Nikolaus and Sachin, just to conclude the perspective of SEP and what you see upcoming on your respective markets. I mean, David, you're based in the US, Nikolaus, you're based in Berlin, in Europe, and Sachin, you're in Asia Pac. So maybe, David, a little word of conclusion.
Yeah, well, first of all, thank you for providing the opportunity for us to have this discussion today. You know, I would say things are very dynamic in the US. In addition to the issue I mentioned about anti-suit injunctions, there are unresolved issues about disclosure obligations. There are unresolved issues about valuations. There are even unresolved issues about who does the valuations. People may be aware that after a judge in California wrote hundreds of pages of opinion valuing a large portfolio, the Court of Appeals told him the jury should have done it, without really giving him any guidance on what the jury is supposed to consider. And so it's just really a very interesting and dynamic area that I expect to continue to evolve over the next 5 years.
Thank you, David. Dr. Thumm, Nikolaus.
Yeah, sorry. Okay. Well, last statement. I think I would very much like to see, you know, to increase transparency, generally speaking, in this field. That's Questel's work, but there is others involved. Mm-hmm. And to reduce transaction costs with the aim simply to reduce litigation. I think that I would put as an aim here. And I believe that it's on all sides to contribute to that. I mean, all the parties involved, the private parties that are, be it licensors or licensees. I mean, they in their negotiations, of course. I mean, I think they can contribute a lot. For instance, I mean, SEP holders by making right from the beginning good. Good patent claims, good standard contributions of high quality, transparent, and so on. Also, when you enter into negotiations are, of course, so FRAND is a raid. So, of course, and you want to get the best out of your negotiations. I mean, that's clear. That's naturally the case. But still, if you enter into negotiations, you know, with a transparent and trustworthy position, I mean, in the long run, I think you also gain. And I think that type of attitude is important from the private side, I believe. From the public side, I mean, we were discussing that at the very beginning. I do believe if we want to reduce these transaction costs, the high transaction costs that we have in this field, I think it can only happen, you know, with international collaborations, and I do not think it's the unwired planet approach. I do believe that there is international institutions that exist already that could be helpful in that respect, but maybe they're even also there, you know, they need a little push, or maybe they have to be developed a little further in order to make that happen.
Thank you for this view, Nikolaus. Sachin, you have the last words.
Yeah, thank you, Gilles. Thank you, everyone, for your time. Thanks, David and Nikolaus. So yeah, as David said, it's a very evolving situation, with so many lawsuits going on. And, I have been fortunate enough to be part of some of these, landmark cases, both in US and Europe. And, I think it's a very evolving scenario. And we have to see how the next 5 years unfolds, because with 5G, IoT, connected devices and all those things going on, I think it will have large implications for various industries. And I'm also very impressed by suggestions that Dr. Nikolaus has provided, about bringing more transparency in the system. I think that's the need of the hour, and we look forward to playing our role in this field. I think we have been doing a lot to bring in more transparency into the system. But we look forward to seeing how we can continue playing our role.
Thank you very much. Thank you, David. Thank you, Nikolaus. Thank you, Sachin. Thank you to the audience for participating to this roundtable. The session has been recorded, so we'll be happy to share that afterwards. Don't hesitate to pop up and send us an email. You got our email address on the screen, and we look forward to meeting you to another session soon. So have a good day or good evening for European people, and thank you very much for attending this roundtable, and thank you, Sophia, for helping us organizing that. Thank you.
Thank you, everyone.
Thank you very much.
Goodbye.
Thank you for the great discussion. Thank you. Bye.
Bye-bye.